To be clear, I want everyone listening to know that if you think you're going to tell me what to say, how to say it, when to say it, or to whom to speak, you have the wrong girl. All right. Welcome to the JudgMental Podcast. I am back, excited to be here. Let's get right into it.
Welcome back, except for you're back and you're not back.
Well, yeah, I'm remote living the dream right now, and I'll be remote for a week or two, but not on set, although on set, LOL. But I did think I might as well just go to their family court down here and do a roll call, don't you think?
Oh, that would be very cool.
Yeah.
What county?
So I think I'm going to try to do that on Wednesday.
Okay. What county are you in?
Pinellas.
Okay. In case anyone's listening down there.
Yeah, there's a lot of reviews online that do not appear that things in Florida are going well. And actually, before we get into the Louisville CLE, the family court had, and we'll talk about everything that we got from sources from that. Did you know, I got a buddy in Florida that says that attorneys, if they disparage judges, they can get in trouble with the bar. Have you ever heard that?
No, I've been concerned that there will be such interpretations. I would imagine I can see the bar in various places being weaponized. What jurisdiction specifically were you hearing about?
Florida.
Oh, yeah. So Florida, my understanding is that their rules are incredibly draconian. The attorneys that I worked with that were Florida attorneys felt like they were looking over their shoulder all the time, no matter what they were doing, and anything we proposed, anything regarding the website, anything marketing related, anything that we said, what our URL was. Like, I mean, the lens that everything was interpreted through, it just seemed to be extremely strict, to the point where we ended up hiring someone and paying them to consult with us, someone that was actually maybe had been the head of the bar in Florida, but someone that had worked on the bar and was an ethics attorney, just so we could consult with over anything that we did once we had a Florida office. Yeah, it was tough. I mean, they've got a lot of different rules, so I wouldn't be surprised. It was something when we began doing this that I was definitely conscious of.
Yeah, I mean, I think it's, my understanding from my buddy is that it's like written in their rules, which certainly we don't have in Kentucky. And I mean, come hell or high water, we're going to have, for me personally, before you start infringing on my First Amendment right, I'm not going to go down without a fight. You know what I mean? Obviously not a physical fight, but a litigation fight. We got to be clear because we've got some listeners on here that are just like screenshotting and freaking out. But it is clear they are watching our podcast. So let's jump right into this CLE that the family law bar had in Louisville, Kentucky.
Sure. Yeah. The LBA hosted a family law CLE, and they do this each year. Sometimes they do multiple ones, and it includes attorney presentations and a judicial panel. There are also judges that attend and, ask questions or weigh in, even though if they're not participating in the panel. So it started off this year with discussion of Adair versus Emberton, and specifically how FOCs work within the court and whether they can testify or speak at motion hour, and whether parties can actually waive the rules under Emberton. And I will say, I was happy to hear some attorneys vocalize that they don't believe that it can be waived. And people talked about how this is something that really can't happen. And they also highlighted a lot of the differences between the way Jefferson County motion hour works versus other counties.
Yep. And I mean, it's one of those things, though, where it's frustrating to me that they are continually having conversations. It can't be waived because it can't be waived because the statute says it can't be waived, and because the case law says it can't be waived. And you have people that are still trying to waive it. And that's what's so frustrating to me. I wish the attorneys would spend more time advocating for, their clients' due process rights, as opposed to trying to figure out ways to make the judges and FOCs' life easier, or to score points with the judges and FOCs.
Yeah, I mean, I think there's two camps of attorneys. There are clearly people that believe that you can't properly have children's best interests represented in court without GALs and FOCs. And I think a lot of people think, or some people think, that you got to have both if there's enough money involved in order to properly represent a child's best interest. Certainly, you and I are not in that camp. And then there are others who are extremely frustrated with the FOCs, with the custodial evaluators, with that process and how it goes. And I think from my understanding, both were sort of represented in the questions and the discussion when they were discussing this issue.
Yeah, I think they were both considered in the discussion, but I do think it's interesting to note that the discussion that was different from those on the panel as opposed to those in the audience. So
Yes,
it seemed like
correct.
those on the panel were very, very much just like, I mean, at one point, it's my understanding that one of them said anything can be waived. And it's like, can it? Can anything be waived?
Yeah, that's right. And it sort of started a discussion over whether, okay, what if it's waived? How can attorneys waive it when their clients aren't there at motion hour?
Right.
And I think it was part of a discussion about whether or not motion hour is a hearing, because as we've talked about in the past, Adair pointed out, the rule that FOCs, before they can testify, have to issue a report at least 10 days before. And it has to be, everyone has to be provided with a copy of it. So in this discussion last week, you had some judges chime in that, their prerogative was often trying to get through motion hour and get everything processed within an hour, and that the FOC helped in that regard. And then the different people discussed whether or not motion hour is a hearing, and that whether a report is required for a motion hour. But then an attorney, I believe, pointed out that if the clients aren't there, how are you going to allow testimony anyway? How are you, if you don't have witnesses, how can motion hour be a hearing? And so how are you going to let an FOC, quote unquote, testify if you're not actually having a hearing?
Well, yeah, and to back up, like, obviously, I know Adair is your case, and you taught everyone, you made this case law, but like, according to Adair versus Emberton and the statute, the friend of the court, which is someone that's appointed to represent the kid, has to file a report 10 days before the hearing, is a fact witness. And so the frustrating part for me was they're trying to say, because the court even said this is a due process, but you cannot waive your right to cross-examine the friend of the court. But the judges and the FOCs want to still be able to talk at court, which clearly, in my opinion, the statute and the case law prohibit, period, hard stop, right?
Yep, I agree. This is a witness. I mean, what other witness can come to motion hour and speak, not sworn in? Yeah, unsworn. And then even, playing devil's advocate, if someone says, okay, we'll swear him in and let him speak. Well, then who else is getting sworn in? How are you going to have one witness testify and not let others testify at motion hour? I mean, it's just, you're going to go down this slippery slope until you may as well have a full hearing. And there are motion hours in Kentucky where that happens. So there are a lot of counties you go to and you bring a motion, and if it's going to take longer than, so long to argue, then you have hearing. And the witnesses are sworn in. It might be a short hearing, but you have the witnesses, you have two attorneys usually standing up at podiums, and then anyone else that needs to testify, and they will do it at motion hour. But that's not the way that it happens in Jefferson County. So Jefferson County sort of represents it's just a different case. It's just a different circumstance where this issue really comes up. Now, I think if you were in a different county, you would still have the 10-day rule. So even if everyone is sworn in, you're still dealing with, okay, someone brought this motion. Usually a motion isn't brought more than 10 days out. So it would be very rare, unless there was an intervening holiday or something, that an FOC would have a chance to file a report within 10 days and still appear at motion hour to testify.
It's almost just like a silly conversation that they're having. Like, I did something, and y'all know I've got a criminal background, but it's almost as though after Miranda, you have a bunch of prosecutors, and Miranda is the case. Ernesto Miranda gave us that you have to have a written waiver for your Miranda rights. That's your right to not incriminate yourself. And a waiver has to be knowing, voluntary, and intelligent, right? So after that Supreme Court case came down, imagine a CLE when you got prosecutors, public defenders, and judges being like, hey, Miranda's really inconvenient for us. Can we just all get together and waive it? And you can waive anything, right? And judge, people saying the attorney can just waive it without talking to their client. And then on top of that, to go to this whole motion hour argument, which I thought was just like embarrassing for lack of a better term. But I mean, arraignments aren't, no one's sworn in arraignment. So can a public defender just waive a client's Miranda rights without talking to the client? I mean, the whole conversation is stupid is what I'm trying to say.
Well, I mean, that's a great analogy, because if the whole idea that an attorney could just go in and waive Miranda or any of those rights without speaking with their client, I mean, it's obvious that you can't, and you wouldn't do that. And I don't see why it's not obvious here as well. I mean, we've talked about it in previous podcasts. I don't want to belabor it, but I don't believe that attorneys, without speaking to their clients, even if this were a right that's waivable, we're talking about part of due process. If you're just standing up there and you just flippantly say, yeah, that's fine, I will waive it on behalf of my client. Haven't talked to them about it. They probably don't understand what that means, but I'm going to waive that. Let's just see what happens. I think there's some liability, there's some real problems for the attorneys.
Absolutely. And then the former judge, now mediator, that kind of commentated like, well, you know, it was just motion hours were just chaotic. And it's like, okay, the fact that your courtroom is chaotic doesn't mean you can just violate due process. Like, in fact, it's the exact opposite. It's silly.
So I'm not surprised that being able to have an FOC give an update of what's going on at motion hour is helpful to a judge when ruling on a motion, right? If someone files a motion, this person is still talking, you know, they're not supposed to talk about the case with the kids, which we used to see coming up in family court cases all the time. And the FOC had talked to the kids just to find out what was going on, and then comes in and says, yeah, judge, it's my understanding this stuff is still going on. If the judge has to make a call on that motion, whether this needs a hearing or not, I can understand the inclination of judges to want to hear from them, get that factual basis so they can issue an order and stop the problem before it's getting worse. The problem is you can't make the factual findings based on someone who's not sworn, who is in there that's just sort of talking unsworn, and you don't have any other testimony. That's just very problematic. And what other sphere in court can you bring a motion, you bring one witness, and they testify, and then a finding is going to be made and orders are going to be entered? It's not proper, even if it is expedient.
Yeah, and I mean, I understand the inclination that judges would want to go to school and talk to the kids about what's happening. I understand the inclination of wanting to take ex parte information in order to protect a child. That being said, it's Los Estados Unidos, and we, you know, have a constitution. Like, this is not rocket science. This is what's so frustrating. Like, I want to beat my head against a wall when I hear a bunch of family law attorneys sometimes talk about stuff. Like, imagine if like personal injury attorneys were talking about this, or if public defenders or criminal defense attorneys were like, well, I want to protect society from someone that commits crimes. I mean, it's a court of law. I don't understand. I don't understand the amount of time wasted by them on this when they don't even read motions, allegedly, a lot of the times, allegedly.
Listen, I'm happy that they're talking about it, and I'm happy that it wasn't just in my understanding, it wasn't just a room full of people that were in support of waiving it. And here's what we're going to do so that we don't get appealed on it again, but that we don't have to really follow these rules. I mean, there was pushback, I understood, every time something was suggested. Maybe we can do it this way. Someone else would raise an issue with that. And I'm happy that discussion is taking place, because I don't think there were many people that even questioned it for the bulk of the 20 years that I practiced. So I think that's progress. I think it's a very healthy discussion. I think when you have presentations made by people who are actively, at least one of which is actively acting as FOCs in cases, you've got somebody that is used to doing it one way and sees practical limitations if you can't come in and educate the judge. So, I mean, I can see that, but it doesn't change anything. You're absolutely right. What if this was another sphere of law, any other sphere of law? And there isn't a difference. This is still the law. Due process is the same. The standards for, you know, that you have to make factual findings with proper evidence and witnesses that are under oath at a hearing before you can issue orders, that all applies. And there are ways you can issue restraining orders or injunctions while a case is pending, and the rules are very strict, and they are very specific, and they are followed in other areas of the law. and they're not accepted with very limited statutory issues like, some temporary orders, excuse me, are specifically described in our statute and our statutes, provisions for temporary maintenance, for temporary parenting schedules, for temporary child support. And there are specific processes for that. But all of these other things fall outside of those exceptions. So you have to go through the normal legal process. You have to have hearings. You have to have witnesses be properly sworn.
And the legislature spoke and the judiciary spoke. I mean, and I really think, to pivot a little bit, like, the Court of Appeals is just clearly sick and tired and put on notice that Jefferson Family Court, our Louisville Family Court, is not doing what it needs to be doing. Do you know what I mean? Like,
yeah, I mean,
clearly.
It was in 20 years of my practice, we just sort of, in my old firm, joked that the appellate law in family law moved at a glacial pace. The legislators actually changed statute faster than you had, case law made for a long time. And now it really seems there's a lot of case law being made, and it's being made largely from cases appealed from Jefferson County. And that even in unpublished cases, they are pointing out these same problems. And I think a lot of times they're not published. Well, actually, I'm surprised the ones that are published, because these are things that are not novel, but I think they're trying to make a point. And some of these unpublished ones, I think they're not published because, it's the same point that's been made many times and is clear under the law, and they feel like, great, we're having to make this again.
Yeah, and I think that, so for published and unpublished opinions, the Court of Appeals and the Supreme Court both have the ability to decide whether or not to publish or unpublish an opinion. Now, Hugh is much more of a scholar in all regards, probably, than I am, unless it comes to Real Housewives or Bravo. But he puts a lot of weight on published versus unpublished, which it does matter from a legal standard, okay?
Sure.
But I don't necessarily think, for me, it matters as much. And I kind of think the reason that, well, hear me out on this. I think the reason they're leaving these cases with blatant due process violations, and I'm not saying this, they're saying this, okay? But I think they're leaving those unpublished because they think it's so rudimentary, because most of them didn't practice family law. So they're like, at first when it happened, it was out of, like, I believe Judge Ogden's court. They're like, okay, this is a one judge type situation. And then they've got stuff coming out of, like, Gatewood's court. And they're like, okay, wait a second, maybe this is a 2 out of 10 situation. And then you've got stuff coming out of another one. I think that they were having them unpublished because, to your point, the novel idea of due process is not novel. You know what I mean?
Yeah, I mean, generally cases are not published unless it is something that hasn't been dealt with before. It's novel, it's new, and statutes don't address it directly, or there is some confusion in the way that a statute is being interpreted in the courts. And the appellate courts, either the Court of Appeals or Supreme Court, at least in Kentucky, they're called different things in different states, will look and say, okay, we want to settle this matter. We want to say how this law should be applied and what people need to do under X, Y, and Z circumstances. So a lot of these cases that are coming down, it's just the same stuff. Like, the law is clear on it. Generally, you don't see published opinions where they're just having to point out obvious things. One that I wish had been published, one that came out this year, another case that came out of Ogden's court, I believe White versus Cole. And this came out and it defined, it's been defined, but it reiterated that friend of court is a witness. And they are subject to the same rules as witnesses. They have to be sworn in. They also have to be separated from other witnesses when you have a hearing. And that means there are rules on the segregation and separation of witnesses. When someone is going to testify at some point in a hearing, they don't get to just sit in the courtroom and listen to all other witnesses unless they're a party. If they're a party to the case, you get to sit there and listen.
And to back up, Kentucky lawyers will call this rule literally the rule, okay? It's called invoking the rule, and it means witnesses that are going to testify can't be in the courtroom while testimony's happening. Yep. So you walk into any trial, I'm talking a criminal trial, a civil trial, the first thing that's going to happen is they're going to, quote, invoke the rule. It's so basic, so rudimentary, so low level that I can't even articulate how basic it is.
Sure.
Right?
And in White v. Cole, they addressed a situation that we saw all the time in family court.
I never saw it.
You never saw a friend of court being left in the courtroom?
I would have had an actual real time stroke.
Oh, I fought hard. I got into heated. I mean, when I say heated, like professional, but where you repeat yourself and you keep making the objection, not just you make the objection and you are overruled, which you're supposed to shut up, but that it's so fundamental and so harmful to your client's case and muddies the record so badly that it's basically an automatic appeal. So anything that happens, win, lose, or draw, like if you're an attorney sitting there and the judge is making this kind of an error, even if it might favor your client, it's probably something to talk to your client about objecting anyway, because it's going to give the other side the ability to appeal and hold up a ruling for a year and a half, while it goes through the appeals process. It's just very fundamental. But I would see
so many things in that, yeah.
Yeah, and I would argue, and I would say, okay, the FOC needs to be excluded. Oh, no, I think he can stay or she can stay. Well, that's not what the rule says, and I would get overruled every single time. I just would never get excluded. And I think it was back in the day where FOCs and GALs were pretty much interchangeable. GALs get to stay in the room. They are attorneys appointing kids, and attorneys get to stay in. They get to hear the witnesses. They get to cross-examine witnesses. And I think that even though our courts, pretty long ago now have separated the two rules out, there's still this, people that have been in the practice long enough, and some judges still, for some reason, think they have a right to be in the courtroom, and they have to be separated if someone asks.
I mean, it's beyond insane. And I do think that White v. Cole was downplayed at this CLE. And I do think that we should save that a little bit for next time as far as invoking the rule. Because I feel like we get it right, like a little high level, like you just said, 17 genius legal points and actually trial prep points for what you should do to preserve the record. But there was so much, per usual. You said 39 legal things in a 5-word sentence, which is brilliant. I'm not trying to say that. But it is such a big deal, and it was shocking to me to see how they downplayed White v. Cole, but then yet are still arguing Adair. You know what I mean?
Well, I agree. I think, at least from my understanding at this CLE, they mentioned White v. Cole, which I was happy about, but they were talking more about, when they were talking about waiving Adair, it was in the discussion, I believe, about whether or not the FOC would have to be sworn in before making a statement. And I think White v. Cole was brought up because White v. Cole, one of the many things that was stated in it is FOC is a witness. That is why they got into the rule, because it applies to FOCs because they're witnesses. So I think that's, to the extent that they might have downplayed it, it might have been they were just raising it for one specific point, which was relevant to the discussion. And that is, like it or not, FOCs are witnesses, and like other witnesses, have to be sworn in before they can open their mouth.
Yep. Could not have said it better. Well, I feel like we can kind of wrap up for today. I mean, unless there's anything else that you've seen recently that you want to chat about.
No, I mean, there are some things going on in Motion Hour that are worth talking about, but they're not super, super urgent. And I know.
I think we can talk about that on the next one, because I saw some things.
Yep, that's fine with me. I'm just happy you're back, and we can address all the things that have happened while you've been out.
Yeah, just really briefly, I'm so glad to be back. I just needed a little break. I'll be very clear that Orange County, seeing what was happening in California without knowing the players was very, I know I use this word too much, traumatic, but I am genuinely concerned that Louisville is going to become like California. And the fact that these parents in these states without cameras, they are being gaslit in a way that's very different than what's happening here. And they can't get access to their files. They can't get access to a video recording. And so they're being gaslit from every area. And just to see the emotional turmoil that they were placed under. And then obviously to come back and just, feel like everything's happening from all angles. But anyway, to be clear, I want everyone listening to know that if you think you're going to tell me what to say, how to say it, when to say it, or to whom to speak, you have the wrong girl. That's not going to happen. And see how it works out for you. If you continue,
I can attest to that.
Yeah. So, And I mean, I'm open. I've been wrong before. I'll be wrong again. I am by no means perfect, but we got to calm down just a smidge. But I am going to take a break from some of the lawyers here in Louisville. And I feel like just look more objectively at the system, because I do feel like I was giving them some deference having been a litigator in that place. But I do think that, they need to be very cautious of the things they're participating in, because the system, in my opinion, is in real trouble.
Yeah. I second your fear that, Louisville might become like California if they start setting stricter rules for letting people have access to their case file or look at things, or the public from viewing the court. And I've said here that your experience in California has made me very thankful for how open things are here, and how discussions do get started when people are able to watch and see what's going on. It shouldn't really take published appellate decisions, and I don't think it necessarily does when, people are talking. I know that other attorneys pull cases that they're not involved in and watch to see, how judges have ruled on things. I've done it when I've had, someone has told me about a similar case that's going on. It was important to my practice, but I also think it's really important in discussions about how, things like Emberton and the Adair case and due process is carried out in family court. And I'm happy that discussion is taking place, but I don't think it would if we didn't have open courts the way that we do.
Absolutely. All right, y'all, judge-y.com. Send us everything. I am Kentucky Christine on TikTok and Instagram. We are Judgy on YouTube and Judging the Judges. Also, you can search Judgy on Instagram. Tell us your stories. Thank you.
Thank you.
We need some justice. My life is fine, justice.